Nice tribute there from the Bryant Law Center for the military folks.
Yeah, it's my dad. I'm very proud of that and of him.
Yeah, indeed. Well,
and Albert. Yeah, Albert Jones, my uncle.
Yeah, a little bit of everybody in there, the whole family. This topic this time for the Bryant Law Center is divorce. That's the focus of what we have. If you have a question for the attorneys, give us a call at 1-888-208-6946. And Joe, we have one already. And Maggie wants to know, will my spouse have to pay for my attorney if I don't want a divorce?
Well, typically no, at least not for that reason. There's no penalty for being the one that wants to file or being the one that wants to go ahead and proceed with the divorce. If there is an award of attorney's fees, it's usually associated with some big disparity in your income, or if one party has done something to make the case much more expensive and needlessly so. The court has the ability to offer an award of attorney's fees, but that's something that usually happens at the end, but it does not typically happen just because you didn't want to get divorced.
Here's an interesting question from Tim, who says, my wife started a business a couple of years ago. What rights do I have to that business if we get divorced?
Well, the law starts with the presumption that anything that was acquired during your marriage is subject to division at the time of your divorce. So if she started that business while you were married, if you go on to get divorced someday, if that business has any value, it is subject to division at the time you guys go ahead and part ways, as long as it wasn't started with funds that she received from a family member or some other non-marital source. But for the most part, anything that you acquired during your marriage, you get to divide up if it has any value, or if you owe any debt on it at the time you go ahead and get that divorce.
Mike says, I've received a document called a status quo order. What exactly does that mean?
Yeah, a status quo order is an order that is entered in almost all divorce cases, and it essentially says nobody change anything that's going to operate to harm your soon-to-be ex-spouse. Don't change any auto insurance policies, don't cancel any life insurance policies, don't clean out the bank account, don't go run up a bunch of debts. Basically, it's like hitting pause so everything remains as it is. So when you go ahead and divide out all of those debts, all of those assets, nothing has been changed and nobody's interests have been harmed because you decided to go out and do something while the case was pending.
Got a little bit of time left here, and an anonymous viewer says, if neither of us can afford the mortgage on our home, what happens to the house in the divorce?
Yeah, well, if no one can afford the home or neither party wishes to retain the home, there's really only one option, and that's to sell it. So you hope to maximize the value that you can. Oftentimes, selling a house in divorce is not the best option. If people know you're going through a divorce, they try and get a good deal off of you at some points. But if neither party can afford the house or neither party wants the house, that's really the only option that you've got.
And one last quick question: will Illinois accept a divorce that was granted in Kentucky?
Yes, it does not matter what state you get divorced in. All 50 states will recognize a divorce in another state. So you're divorced all over, even if you got divorced in the state you don't live in.
Okay, well, we are just about out of time.